Our next presenter is Jennifer Schaefer, who's the Executive Officer of the Board of Parole Hearings in California. This is Ms. Schaefer's second appearance before the committee. Her first appearance concerned the issue of lifers, which we were just discussing at length, especially with Justice Klein. Today, Ms. Schaefer will be speaking about the early parole release procedure for people convicted of nonviolent offenses and given special parole consideration under Proposition 57. This is, I think, a less well-known aspect of the parole population, but it's a huge number. Again, I think that Ms. Schaefer will give us all the data here, but I believe it's about 20,000 people who are eligible for Prop 57 parole consideration. Unlike the other panels, she'll give a little bit of a longer introductory statement given the amount of information and data she has to present. And then, of course, we'll move to questions. So, Ms. Schaefer, thank you again for joining us. It's good to see you. And I hope that you have the ability to share your screen because we'd love to see the data.
Oh goodness, I apologize. I did not.
Okay, if that's, I'm sorry. I didn't mean to put you on the spot. You take it away however you wish. We have your report. So go ahead.
I was actually not planning on covering all of the details in that report. So please feel free in the question and answer section to ask any questions you may have about the report. What I wanted to do, first of all, good afternoon. Thank you for having me with you here today to talk about the nonviolent, what we call the nonviolent parole review process under Proposition 57. As you know, Proposition 57 was passed by the voters in November 2016, and it amended our Constitution, and its intent was to enhance public safety, improve rehabilitation, and avoid the release of prisoners by federal court order. So for purposes of today's discussion, I want to focus on three provisions of Proposition 57. First, it established that persons convicted of nonviolent felony offenses and sentenced to state prison are eligible for parole consideration once they have completed the full term of their primary offense. And it defined full term for the primary offense to mean the longest term of imprisonment imposed by the court for any offense, excluding the imposition of enhancements, consecutive sentences, or alternative sentences. Second, it gave the Secretary of the Department of Corrections and Rehabilitation the authority to award credits for persons who are incarcerated. And lastly, it mandated that the department adopt regulations to implement those provisions and that the Secretary certify that those regulations protect and enhance public safety. So now I'd like to give you a little bit of history and context for Proposition 57 and these particular procedures. As you know, and has been talked about a lot, I know in your committee meetings, for the state for years prior to Proposition 57 had a problem with prison overcrowding, such that the courts found that the state was unable to provide constitutional level of medical and mental health treatment. In 2011, we had criminal justice realignment that just shifted the custody for many lower level crimes to county jails. Shortly thereafter, though, I'm not sure how many people are aware, but we saw a significant increase in the number of state prison admissions for nonviolent second strikers out post realignment. And the prison population was still too high to provide constitutional level of care. In 2014, the three-judge panel in the Coleman-Plata litigation issued an order requiring the state to implement several population reduction strategies, including increased credit earning, a parole consideration process for determinately sentenced, nonviolent, non-sex registrant second strikers who had served 50% of their term, as well as several other measures. In 2015, the department began referring nonviolent second strikers to the board for parole consideration under that court-ordered process. However, in designing the process, it was determined that it would be in the best interest of public safety to exclude persons with recent negative in-prison behavior from that process. This also allowed the state to focus its resources on those who are most likely to be approved for release. Additional credit earning was also implemented at that time. When Proposition 57 was enacted in 2016, it was considered to be a durable solution to the state's overpopulation problem. in that it made permanent some of the processes previously imposed by that 3-judge panel, specifically a parole process, albeit expanded, for persons convicted of nonviolent offenses, and expanded credit earning that could be implemented via regulations by the Secretary. The state promulgated regulations implementing Proposition 57 in 2017, and the nonviolent parole review process implementation that was implemented at that time was very similar to the court-ordered parole review process. Courts have subsequently expanded the nonviolent parole review process based on the plain reading of the text as it appears in the Constitution. For example, courts have held that the department can no longer screen out persons based on negative in-prison behavior. Persons required to register as a sex offender are now eligible, as are indeterminately sentenced nonviolent third strikers. So now I just want to quickly turn to a summary of the process today. First, I want to distinguish between the parole hearing process, which you just spoke a lot about with your last panel, and this parole review process under Proposition 57 for determinately sentenced nonviolent persons. So for indeterminately sentenced persons who are eligible for a parole hearing under Prop 57, they get a full parole suitability hearing, just like the process you were talking about. Commissioner, a deputy commissioner, just like other life term inmates receive. The only difference is that they're eligible for parole consideration earlier in their sentence under Proposition 57. For determinately sentenced persons, the board conducts an administrative review. It is a paper review process. There is no hearing. This allows more people to be eligible for review more quickly and more often. This is because there's a very high percentage of people who are referred to the board after under the nonviolent parole review process after serving less than 2 years. In April of this year, 64% of people who were eligible for the nonviolent parole review process had served less than 2 years. And more than 20% of eligible persons have less than 2 years remaining on their sentence at the time they are first eligible for review. So with the paper review process, the process takes 3 months for the board's portion of the process. And the person is released 60 days later for a total of 5 months from beginning to release. And that person is eligible for review annually thereafter if they're not approved. In contrast, the parole hearing process takes roughly 11 months from the time that we schedule a hearing, appoint counsel, do the hearing, and then the decision review process, including review by the governor. And for the parole hearing process, Marcy's Law applies. So if somebody is denied, they're denied for 3 years minimum, as opposed to the annual reviews under the determinately sentenced nonviolent parole review process. Another significant difference between the parole hearing process and the paper review process is that the paper review process is conducted by the board's deputy commissioners. Deputy commissioners are administrative law judges and licensed attorneys. They come from a wide variety of professional backgrounds, including experience in family law, criminal defense, immigration law, and juvenile dependency. They receive extensive training on the law governing the board's decisions, risk assessment, correctional policies, disabilities and reasonable accommodations under the Americans with Disabilities Act, implicit bias, and structured decision-making. And their decisions are routinely reviewed. The board currently employs about 50 administrative law judges or deputy commissioners, as opposed to the 17 commissioners that we currently have on the board. Since 2015, the board has approved over 8,500 persons for release under the nonviolent parole review processes, both the court-ordered and the Prop 57. And the board remains committed to making the most informed decisions possible based on the law and relevant evidence-based research concerning risks and recidivism. I'm happy to take hopefully, was that under 10 minutes, Michael? I was trying.
It was excellent. It was 7 minutes. Perfect. All right. So I have a bunch of questions. Let me just clarify. So first of all, for the Prop 50, let's just focus on the Prop 57 parole process. When you're saying that there's the indeterminately focused nonviolent folks, those are the 3 strikers.
Correct.
And they get a traditional
parole.
parole.
There are some others, but the majority are 3 strikers.
Vast majority, correct. The others go through the paper review process.
Correct.
The standard for release is the same though, right? Is the board applying the same standard, and what is the standard?
So for the parole hearing process, that has been developed mostly through case law, as you know. The current standard is, does the person pose a current unreasonable risk of danger to the public, of dangerousness? Under the Proposition 57 parole review process, the paper review process, the standard is that whether or not the person poses an unreasonable risk of violence or significant criminal activity. And there are factors, specific factors to be weighed and considered. There is a presumption. So let's see how I explain this. We use structured decision-making as a model for the regulations. So what we did was there are, I think, 4 different areas that the deputy commissioner looks at. And they rate basically whether their prior criminal history is aggravating or mitigating. And they list specific factors that require them to find whether it's aggravating or mitigating. They look at their current commitment offense, and based on some of those factors, determine whether it's aggravating or mitigating. They look at their programming and their behavior in prison, and they determine in each of those areas whether it aggravates or mitigates the risk. If there's nothing, if there's no aggravating factors, or if the aggravating factors are outweighed by the mitigating factors, they shall approve them for release.
Is that different than the ordinary parole process?
Yes. It is.
So what's the ordinary parole process when you find those similar factors?
So in the parole hearing process, we have access to a different additional information. So we're looking at parole plans. We're also looking at what is deemed in the structured decision-making offender change. And what we're looking at in that offender change dimension is how much has the person changed from when they came to state prison? And who were they then, who are they now, and sort of what the difference is. Do they have pro-social attitudes, things like that. You can do that in a hearing when they're represented by counsel. You can ask them what have they learned in their various programming while they're here in state prison. In the paper review process, that information is not consistently and readily available to the board. So we did the best we could using the information that we have available. We also use in the paper review process, we look at the California Static Risk Assessment Score, which has been validated on shorter term determinately sentenced persons, as opposed to in the hearing cycle, we use forensic clinical psychologists administering the HCR20 and the Static 99.
I have a million questions, but I won't monopolize your time. All right, hearing nothing from my other committee members. If we, as a state, said people who are not a risk to public safety should not be in prison regardless of what their crime was. Let's just say that as an assumption right now. And let's take the homicides and ordinary indeterminate sentences off the table. Is the Proposition 57 process a good way, do you think, to evaluate people's suitability for release beyond the nonviolent folks? So in other words, what I'm trying to get at is we've heard a lot of complaints and concerns about enhancements, right? In all sorts of different circumstances, and I don't want to get into it. And Proposition 57 is in some ways a way to ameliorate some of the concerns about enhancements, right? At least for nonviolent offenders, by giving them, or nonviolent people in prison who've committed nonviolent crimes, by giving them a chance to get some sort of parole review before their enhancement kicks in, right? That's when the Prop 57 review takes place. So getting back to the original presumption is, if we wanted a chance to review folks who are not a danger to public safety regardless of our crime, would the Prop 57 process be a good way to expand to to everyone. I realize that the Constitution currently limits it to people who've committed nonviolent offenses, but as this is a matter of policy, would it be a good way to evaluate, anybody?
So I apologize. I just experienced a technical difficulty. I can no longer see you. So I just want to confirm, can you still see me and hear me?
Yes, we can.
Okay, perfect. I will just talk to a black screen. So
Okay.
I apologize. So in essence, yes, I think theoretically, the design of the nonviolent parole review process, essentially what it does is it takes the longest term of imprisonment imposed by the court, which in theory is usually the most significant crime, not always, but frequently it is. And meaning the most violent, right? The one most serious that most people would consider to be most serious. And what it does is it makes them eligible once they've served that particular sentence. And that could be very early in somebody's complete sentence. So I think in the report, I gave you a couple of examples where there are a lot of what they call nickel priors that have been added. There are other sentencing enhancements that turned what was a 2-year longest term of imprisonment into a 20-year sentence. The one caveat I would say to that, though, is that Prop 57 excludes consecutive terms. And so what we found when we went from the nonviolent second striker process to the Prop 57 process is that there were more people coming to the board who had multiple convictions for different individual acts that comprise their entire term. So in essence, we had more people coming to the board with more significant criminality than we did under the nonviolent second striker process.
I'm going to keep going. Yes, Professor Ochin.
So I have just a couple of questions, just clarification questions, and then, well, really the first is a clarification question or question seeking information, and then the other is maybe just a question for the committee to consider based on the staff report. So I'm looking at, I think it's page 15 of the staff report that talks about the approval for release rates under Proposition 57. And according to the staff report, it varies from 23% to 17%. And in 2020, the rate was 17% for the roughly 6,500 people that were referred to the parole board for review. So I'm wondering if you could talk a bit, Ms. Schaefer, about what accounts for, from my perspective, a relatively low rate of approval for release. So that's my first question. And then I have another question about how the panel considers questions of risk of dangerousness or violence or significant criminal activity, particularly in light of the conversations we were just having with other witnesses like Professor Tonry and Professor Path about the relevance of considerations regarding dangerousness, particularly for people who are over the age of 40. So I'm wondering if you could talk about those two things and how they're, one, the grant for release rate, and then two, how the board evaluates questions of future dangerousness.
Okay, so for the determinately sentence process, I'll address the paper review process first, and then if you're interested to go into the parole hearing process, I'll be happy to address that as well. For the paper review process, the approval rates have been relatively low. We look at things like they're risk-based and research-based principles. So in essence, what we're looking for are things that, like if we're looking at criminal history, we're looking to see, has this person had a conviction for a violent felony in the last 15 years? That would tend to increase somebody's risk over somebody who didn't have a prior violent criminal conviction. If somebody did have a violent felony conviction within the last 15 years, if you do the math, it's relatively, they would not have been out of state prison very long before committing the crime that they're in for now. Because by the time they come to us, they've already served the primary term of their new offenses. So we go through sort of this risk-based analysis on each of these factors using things that have historically and in research shown to translate or correlate to increased risks of recidivism. And so things like their current commitment offense, we're looking at their current commitment offense in relation to prior offenses. So if it looks as if the person's overall criminality is decreasing in severity, or what we call density, they're not happening as often, that person's risk is actually going down. Whereas if you have somebody who has had subsequent convictions and that behavior seems to be escalating in severity, that person is going to have a heightened risk of recidivism, potentially violently, than the other person. So we go through a series of things like that. When we get to programming, we're looking at what were the factors associated with that person's commitment offense, why they're in prison today. It could be substance abuse. It could be, that's one of our more frequent ones. It could be impulse control, anger issues, domestic violence, things like that. We are looking for what have they done in prison to address those issues. And we may look at just are they displaying impulsivity? Have they had bad urinalysis tests where they've tested positive for controlled substances while in prison? Have they taken positive programming already? And so those are the kinds of things that we're looking at. That's a kind of a cornerstone of risk assessment throughout the United States and the world, is looking for identifying the person's risks and needs, criminogenic risks and needs, and their responsivity to programming that they've received. So those are the kinds of things that we factor in when we're trying to determine whether or not somebody should be released. What we see often, it was similar to what one of your prior panel members was saying. When we first started this program under the court-ordered system, every single person that came before us had some violent history. But they had already served 50% of their term. And so it was much more remote in time. Now we're seeing people much earlier in their prison terms. And so their recent violent activity is much more recent and much more relevant to their risk. Does that make sense? The other thing you had asked for is how do we consider risk specifically for persons over 40? In the paper review process, the deputy commissioners' regulations require that they take into account a person's age, physical disability, if any, totality of the circumstances, and factor that in when making their overall decision. So it is factored in. Similar, however, to the finding of one of your prior panel members, what we are seeing is that there are people, at least in this process, whose criminality was much more recent. So even though they're over age 40, they aren't part of that overall crime curve, apparently. Many of them are committing crimes later in life. So that's how we factor in age for the determinately sentenced process.
Thank you.
Welcome.
So I have another hypothetical for you. So we're going to hear later this afternoon from about different reentry programs, and particularly from Doug Bond, who runs an MCRP program in Los Angeles. And I was curious, right now, parole decisions, whether they're ordinary lifer hearings or the Prop 57, they're binary, right? You're either in prison behind bars or you're out on the streets. Granted, there's parole supervision, but it's binary. you don't have an option to send them to an MCRP. That's correct. Is that, like, you can't say, close, why don't you go to an MCRP for a year and then you're good to go. All right.
Correct.
If that option existed, do you think that that would increase the number of people who are getting out from behind bars, or just there would be the same number of people, except you'd send people to MCRPs rather than just straight to the streets? You understand my question?
Yeah, I think potentially it could do both. It really depends on, again, we really try to focus our decisions on research-based, risk analysis. So I could give you sort of a hypothetical. If somebody is having a substance abuse issue and they've gone through meaningful programming in prison, but it's only been like a month or 2 months. And so historically, the person may not have done particularly well with their controlling their substance abuse. And so it's probably a little bit early to be suggesting that they've fully mitigated that very serious problem that they had. But if you had an MCRP that was a supportive environment and had continuing programming for that person, however that would be defined, then yes, I think that is it's a viable option for increasing approval rates for this particular cohort. It would really depend. We still have quite a few people in state prison who don't have access to the victims, their normal victims. So if you're talking about sex offenders who are attracted to children, people who have interfamily conflict, those are a little bit harder to gauge based on in-prison behavior. So we look more toward programming in those cases. And when we're able to have a hearing, interviewing them and asking them specifically about how they're processing those issues today.
Would you welcome an opportunity, the MCRP option? Let me put that in a different way. So right now your options are stay in prison, come back in a couple of years, or you're free to be released. How about a third option of go to MCRP?
I think the more options we have, the better. That said, I want to ask if I should know the answer to this and I apologize, but people that go to MCRP, there's no difference between folks that go on parole versus going to PRCS, correct? You go to an MCRP, or you would go to this intermediate place, technically in custody, but once you were done with your term there, then you would go on to supervised release as prescribed by law. Is that correct?
Correct.
Okay. Yes. I think having an option like that would be helpful. It's certainly the model in many other states and several other jurisdictions.
Do you have an impression about how people in prison view the Prop 57 process? Like, obviously for lifers, the board and the prospect of going before the board occupies a lot of time and attention, at least hopefully, and at least for some people. The Prop 57 process is less well known, certainly among the public. Do people in prison, as far as you know, are they aware of it? Do they understand? Do they program? Do they, with a goal towards impressing the 57 paper review process? Or is it something that's kind of administratively in the background and not really providing the appropriate incentive that we would hope it does?
I wish I had more information about that. We provide documentation. So when somebody is eligible for the nonviolent parole review process, they are served with documents that tell them that they're eligible, tell them the date that they're eligible, and explain the process at a low grade level or low reading level in a way that it can be understandable from a variety of folks. So I think to the extent—
Is that an admission? I'm sorry to interrupt. Is that an admission, or is that later on in the process? Do you know?
So the initial part is within 60 days of admission. You're eligible. This is kind of the the high level, this is what what it is. But then once they're actually eligible for referral to the board, there's a very sort of detailed explanation of what to expect. So I think it's twofold. I think people are aware of it. I think people, whether or not people are working toward it, I think it has evolved. And I think that if 2020 was just a very unusual year due to the pandemic and the stopping of intake, right, of people to state prisons. So I think we have a little bit of a gap in being able to reach out, or what we call in reach, talking to people to get their feedback. If the parole hearing process is a meaningful example, which I hope it is, just the sheer power of hope and seeing people being approved and going home early, and additional programming being available based on this process earlier in their incarceration, I think has to at some point prove to be an incentive.
Justice Marino. You're on mute.
Yeah, thank you for your presentation. Do we have any data yet on recidivist rates on people who've been released under either program? We heard some remarkable statistics earlier on other indications of recidivism, but I'm curious as to what the rates are with respect to the programs you've been talking about.
So for the determinately sentenced nonviolent parole review process, we're on the cusp of having recidivism data. And the reason why there's such a delay is that we do a 3-year follow-up period. That's how the department defines recidivism. So people that would be included in a recidivism report today would have been released in 2018. And we're just now sort of gathering that data, right? Because under Proposition 57, that process didn't really start until 2017. And so there were very small numbers leading up till 2018. The nonviolent second striker process, we have seen some preliminary recidivism data, and the recidivism was definitely lower than the overall recidivism rates, but not nearly as low as after a parole hearing. So for parole hearing, when somebody is granted parole and released after a full parole hearing, the recidivism rates have varied from 2 to 4%. And when I say it's recidivism rate of 2 to 4%, I mean that within 3 years of release, 2 to 4% have a new conviction. And then, so we call that general recidivism. And then less than 1% of each of those folks is actually convicted of a new crime involving physical harm to another.
Thank you.
Professor Ochin.
Thank you. I just have another informational question, which is, I don't know if this is from Ms. Schaefer for our staff, regarding the race, age, and gender demographics of the 6,500 individuals who were reviewed, paper reviewed by the Board of Parole Hearings and the outcomes. So I'm just wondering if that information is available and if it's been made available to the committee, or if it can be made available to the committee.
It can be made available. The department just recently made a determination that race and ethnicity information is a matter of public record. So that information is available. We have not conducted what I consider to be an academic, rigorous study. I think the last time I was before you, I was mentioning the fact that we are very much supportive and looking forward to doing an in-depth academic peer-reviewed study of the board's hearing outcomes. And we're still working on that.
Thank you.
Ms. Schaefer, I think that it's not a secret that myself, at least, I won't speak for others on the committee, would love to see an increased parole grant rate. What would be the safest way to do that, in your opinion?
In my opinion, increasing meaningful and targeted programming.
And you think that if people showed more programming, that they'd have a higher grant rate?
I think that the department and the board need to continue to improve the connection between risks, cognitive behavioral interventions, and support after support of those CBI programs. And I do think, I think there are two things at issue. One is, I really think, I mean, the sheer number of life-term inmates and long-term determinately sentenced persons has continued to increase. It is on a trajectory that has increased considerably, especially in the last 10 years. Last year, we granted parole to 1,234 persons serving very long sentences, the majority of whom are in for murder, kidnapping, rape. That is unprecedented among any of my peers from parole boards across the country. It is a really remarkable thing that has been happening in California. I think that trajectory will continue as more people have hope and are motivated to do more meaningful programming, and that we see more people successfully re-entering society. I really do.
Professor Ochin?
Can you talk a bit more about how programming is evaluated as part of this paper review? That's my first question. Second has to do with my understanding that folks who are going through this Proposition 57 review process do not have the assistance of lawyers. And I know that's pretty common generally, but I'm wondering what effect that might have, especially since they're not able to appear before the board personally. Does that have an effect on how the panel might assess some of the considerations that you outlined earlier in determining whether to grant the application for parole or not? And then lastly, having to do, so this is my third question. So the first is about how is programming considered as part of your review? The second is, would lawyers be useful, especially since this is a paper application, funding for public defender offices, for example? Then lastly, is the impact of COVID on the ability of folks who are incarcerated to access the kind of programming that you are suggesting is so critically important to applications and the board's assessment of the relationship between the things that they have done to rehabilitate themselves around the factors that may have led them to be in conflict with the criminal law. So those are my three questions. Programming, how it's considered, lawyers, whether they be useful, and impact of COVID on the ability of people to access programs.
Okay, so in the paper review process, we have access to electronic records that show what programs folks have been assigned to, what work assignments they've had, what career technical education programs they've been doing, and what education. So we know what they've been assigned to. We can see whether they're attending or not. We can see if they have certain disabilities that might prohibit them from participating in those activities. And we take all of that into account. What we are not doing is being able to assess really their responsivity to that programming. What did you learn from it? We just know that they took it and that they were there. So a person who took it and who was there, in theory, their risk should be minimized or at least lower than somebody who didn't take anything at all and was able to do so. So that's kind of the very high level way of looking at programming. But again, we're also looking for, again, if they have a substance use disorder treatment or substance use disorder, have they taken something to address that? They also have the ability to submit a written statement. And we have the ability to translate those statements. So if they're not writing in English, we can translate them. But those statements are really from them, and they're not something that we can really corroborate very easily. So the majority of our decision is really based on the evidence, the evidentiary record before us. And then you factor in things like what was the severity of the crime, how recent was their last act of violence, if any, and you're looking at sort of the whole package, all of the information. So that's the programming when we're doing, that's how we're addressing programming. And then of course, we're looking at institutional behavior, if they had any rules violations and things like that. That's for the paper review process. Do you have any questions about the hearing process with respect to programming?
Yeah, sure. If you'd like to describe that, and if we have time, I'm also mindful.
Let me finish your other two questions.
Yeah, we have about 5 or 10 more minutes left.
Okay, with respect to whether I think attorneys would help this process, I have mixed feelings about that. California is a very, my experience has been that when you are inserting that kind of assistance into a system, that attorney needs to understand the correctional system, need to understand accessing to programming, needs to understand a variety of things within the prison. Public defenders don't usually have that level of expertise with respect to what kind of programming and what has the person done since they came to state prison. And what we have found in the parole hearing context is that the ability to sit down and interact with somebody and provide meaningful advice within 30 days of referral, right? So referred to us, we wait for input from victims and district attorneys and the incarcerated person and any member of the public. And then we have 30 days to make our decision. That is a very short time frame to provide meaningful legal counsel. So I do question whether this would be a particularly good process for legal counsel. It was considered early on, and the decision was made that we would not appoint counsel for this. So obviously it's open to multiple reasonable judgments about that, but that is where we are today, and those were the decisions that we made. With respect to COVID, first of all, people who, because intake was shut down, and a lot of people were released under COVID and the emergency powers. So people that were within 180 days of release were and they were nonviolent. Many of them were released in order to reduce the population to prevent the spread of COVID. So there were a lot of people who might have been eligible for this process, but for the fact that they were released early. So there have been some, that was sort of a rolling thing that was happening during COVID. So as far as the programming, I will give, I have a lot of respect for a lot of the volunteer groups and our contractors, CDCR's contractors that provide programming. Many of them shift to what we call packet programming. And what we have found in our parole hearings, because of course, after a very short delay, we continued with parole hearings via video. And what we found is that where people could congregate and with social distancing, there were groups of people that were still doing a tremendous amount of self-help. They were also in communication over the phone with many people, some by video. And for a lot of folks who were very motivated to continue with their programming, they did so. And so we didn't see a really significant drop, at least with respect to the people that were coming before the board for the parole hearings. Obviously, we would like to see more robust programming, but it did not come to a complete standstill by any means. For the determinately sentenced short persons that were coming before the parole board, their programming probably did go down a little bit. Although they could also participate in the program, the packet programming as well. I just think within the prison system, the person sentenced to life with the possibility of parole tend to be a more, they're just a more cohesive group within state prison, and especially the folks that are high programming. I hope that makes sense.
Unless anybody has any last questions, I do want to just wrap things up. I'm going to ask Ms. Schaefer one last question. Does anybody else have any questions before I? All right. So I just wanted to give you an opportunity, Ms. Schaefer, to just address the concern that we've heard here in the previous panel, before, multiple sources, about this problem or concern about algorithms versus individual assessments of, yeah, that's where I'm going. And I know that you use a combination of them, and you've referred to the CSRA, the California Static Risk Assessment, which of course is a strict algorithm. You've referred to the CRA, which is sort of what is it? It's a combined or is a guided algorithmic approach because
Professional judgment.
Yeah, structured professional judgment, because it does rely on the CSR 20. Anyway, I was wondering if you could just sort of weigh in on that, on your experience, and how to, and I think the principal concern is to evaluate dangerousness in a way that's free of inappropriate bias, particularly racial bias.
Okay, so here I'm definitely not, an expert. I'm not a forensic psychologist, but here's what I know about risk assessments that I have learned from experts. For the actuarial tools, basically what you're doing is you're taking a cohort of people and you are releasing them. So some will be high risk, some will be low risk, some will be in the middle. You rate them all before they go out the door. And so it's better suited for determinately sentenced persons. You release them all, and then you do a follow-up and you validate that. If you think that based on their criminal history or whatever factors you're looking at, they should recidivate at a lower rate, then you follow up in the community and you find out if in fact that is true. Many times those tools are actually put together, determine those factors. They look at everyone who's previously been released and they try to identify dominant factors that contributed or seem to be correlated with poor outcomes and positive outcomes in the community. So that's kind of the actuarial tools in a nutshell. What they do is they look at these factors that are correlated to outcomes. And then as people are going through the system who meet those same sort of factors or have those similar factors, you then place them in those risk categories based on what you have learned from validating that tool. For an indeterminately sentenced population or folks who have been incarcerated for long periods of time, it's a different scenario. So for indeterminately sentenced persons, if we want to do an actuarial tool, you would have to take a statistically significant sample of the persons who are currently incarcerated to under a sentence of life with the possibility of parole, folks that we have found to be high risk, moderate risk, and low risk for future violence, release them all and see if in fact, the high risk was able to, if a larger percentage of people who were deemed high risk actually recidivate. That's not feasible under our existing laws, obviously, because they're not serving determinate sentences. There is not a specific release date. So for us, actuarial risk assessments for the lifer population is not possible because we would never be able to validate that tool on the population that comes before us. So what I hear, which is a lot of misinformation in my opinion, is that, well, lifers, when they get released, only recidivate 2 to 4%. So they must be overall a very low risk category. The only people who are released are the people that we have found to no longer pose an unreasonable risk to public safety. So in my opinion, it's a significant leap in logic to suggest that everyone who is part of the lifer population in state prison is just as low of a risk as the people that we have found to be no longer an unreasonable risk to public safety. So I think that that's one of the most significant disconnects that I see when we are out talking to the public. What we do instead, since we can't use an actuarial tool, is that we have what we call a comprehensive risk assessment. We have approximately 50 forensic psychologists that work for the board. They have a very long, they have a lot of experience before they come to the board. And what they do when they come to the board is they have a 6 to 7 month training process before they have a full caseload, learning what we do and how we do it so that our assessments can be consistent from one psychologist to another. We administer the HCR20 version 3, the historical checklist revised, HCR, yes. And part of the HCR20 requires, it assesses psychopathy. So they also administer the PCLR. However, that the psychopathy is only relevant to somebody's potential risk for future violence if they score above a particular score on the PCLR. So it's not used to factor everybody's risk, only those where psychopathy is at a level where it does, the research suggests that it does increase somebody's future risk for violence. And then we administer the static 99 for anybody who has a qualifying sex offense. So all of those things are administered by the forensic psychologists after they've reviewed the entire central file and interview the person for roughly 2 to 3 hours. And what they put together is what is called the structured professional judgment. They give us their expert opinion about this particular person's risk for future violence. Now, that's it at a very high level, but what they really do embedded in those reports is the HCR20 reviews 20 different categories or factors. 10 are static, 10 are dynamic. So they're already factoring in what were the risk factors this person had, and where are they today? What have they done to sort of mitigate those risks? And so what they're really doing for us is they're identifying what risk factors for this particular person remain currently relevant. And that's our starting point for a parole hearing in most cases, is what are your currently relevant risk factors? But that is just one piece of evidence, one tool that we use in our parole hearing process. We have an entire structured decision-making framework that allows for variations for the outcome of the hearing based on a variety of other factors that are also based in risk and research and what we know about risk assessment, as well as statutory considerations that we have to take into account.
Well, like I said, I could talk about this forever with you. I mean, particularly, I mean, the algorithms and the HCR20s and how to find a way to identify the people who are least risk to be released from custody in the various different ways. And as we've noticed, or as we've mentioned before, it looks like about half of the people in prison, if you include Prop 57 and the lifers, come before the parole board or evaluated by you or your team in one way or another. And we appreciate it's a huge task. Thank you again for your time, and especially for the comprehensive report and all the data that you gave to us. It really is super helpful to us. So thank you again. I'm sure we'll follow up with additional questions. I want to take a quick 5-minute break between our next panel. So let's reconvene at 3:25.